We will look at a case today regarding the Partition Act and how co-owners have a strong right to sell the property they co-own under the Partition Act. And if one co-owner refuses that sale or tries to deny it, then they can be liable for costs. So the case at hand is Daniel versus Rizzo. It's a 2025 Ontario Superior Court decision. And so what happened here is that the two parties, Tara Lee and Michael, they owned two properties together, a home in Niagara Falls and a cottage in Trent Lakes, Ontario. Their relationship ended, and Daniel sought to get out of the situation and to have the properties sold. And it looks like the other party, Tara Lee, objected to that and didn't want to sell and claimed oppression and other things to deny the sale under the Partition Act. And eventually, it looks like Tara Lee did agree to the sales, but it was too late. Daniel had already incurred a lot of legal fees. So, although Tara Lee did agree, it was too late, as I mentioned, and therefore she had to pay the costs of Daniel. And actually, the case has a twist to it. There was some kind of issue with the cottage easement, so the neighbors also had to get involved as interveners, and they had some legal fees there. But at the end of the day, the legal fees were around $80,000. So it was quite a lot of money that had to be paid for something that could have been easily avoided. So, and essentially, the court reaffirmed that co-owners have a strong prima facie right to a sale. So it's very hard to deny that right. For example, one reason to deny it is oppression. We won't get into that right now, what that means. That'll be for another episode. But that is one exception to the prima facie right to a sale under the Partition Act. And when it's claimed improperly, there can be very, very big cost consequences, as we see here. So the practical takeaway here for real estate lawyers is that if clients ask you what would happen in a situation where they don't get along with the other co-owner, the most likely outcome is that the house will get sold under the Partition Act, and they can do very little to prevent that. As I mentioned, each co-owner has a prima facie right to sell the property pursuant to the Partition Act. There are some exceptions where that can be denied, such as oppression or serious hardship, to name a few. But these things are hard to achieve, these exceptions to the Partition Act. So most likely the property will have to be sold, and it might not be the answer clients want to hear, but if they fight it needlessly, then there can be huge cost consequences, and that's what we see in this case here. So that's the practical takeaway here. If clients don't get along, it's probably best just to have the property sold and for them to cooperate as much as possible, because that is the solution that the courts generally favor when co-owners disagree, and it's very hard to deny that sale under the Partition Act. So I hope you found today's video useful, and I'll see you next time.